This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're talking about the fact that there is never and there can ever be a free lunch someone must pay, and an insured may limit the extent of UM or uninsured motorist coverage it acquires because you only get what you pay for. There is never, can be a free lunch. Sonya Harness was employed as a home health nurse with Volunteer Staffing, Inc. On July 10, 2021, Ms. Harness was injured in a two-car collision. A home health nurse, she was injured in an automobile accident while driving her vehicle in connection with her employment, and she later sought uninsured motorist benefits under a business automobile policy issued to her employer. In a case entitled Sonya Harness versus John Mansfield et al., the Court of Appeals of Tennessee on April 30, 2025, resolved the dispute over whose uninsured motorist coverage would apply, arguing that the uninsured motorist coverage in the business policy did not apply to Ms. Harness's accident. The insurer successfully moved for summary judgment. At the time of the accident, she was driving her own vehicle, a Chevrolet Trax, within the course and scope of her employment. Ms. Harness had insurance coverage for her vehicle under a personal automobile liability insurance policy issued by Tennessee Farmers Mutual Insurance Company. Her policy included uninsured motorist coverage. Volunteer Staffing maintained a business automobile insurance policy issued by the Cincinnati Insurance Company that also provided liability coverage for Ms. Harness under these circumstances. By its plain terms, the policy limited uninsured motorist coverage to injuries that occurred while the insured was occupying an automobile specifically listed in the declarations. Because Ms. Harness's Chevrolet Trax was not listed, the insurer argued that the uninsured motorist coverage in the Cincinnati policy did not apply. By statute, every general automobile liability policy issued or renewed in Tennessee must include uninsured motorist coverage. The named insured may reject coverage completely or select lower limits not less than the minimum coverage limits in the financial responsibility law in a signed writing. It is undisputed that Ms. Harness was an additional insured under the liability provisions of the Cincinnati policy. As required by statute, the Cincinnati policy included uninsured motorist coverage with limits equal to the liability limits for bodily injury. The coverage form specified that each type of coverage in the policy only applies to automobiles shown as covered. By its plain terms, the policy expressly limited uninsured motorist coverage to injuries that occur while occupying the one described vehicle, and Ms. Harness suffered her injuries while driving her vehicle, the Chevrolet Trax, not the described vehicle. The statute mandated the coverage amount. Otherwise, the statute does not explicitly address the scope of the required coverage or dictate the form of coverage. Ms. Harness contended that the statutory requirement is for the protection of persons insured under the policy who are injured by an uninsured motorist, and she is an insured under the liability provisions of the Cincinnati policy. The Court of Appeals noted that the statutory language does not guarantee uninsured motorist coverage for Ms. Harness in this instance. Ms. Harness's rights under the policy necessarily depend on the choices and selections of coverage made by the named insured volunteer staffing that chose to include the mandated amount of uninsured motorist coverage in the Cincinnati policy to a specifically named auto. Volunteer staffing decided to limit that coverage, and those choices made by volunteer staffing did not contravene the plain language of the uninsured motorist statute. Because the Cincinnati policy unambiguously limits uninsured motorist coverage for injuries that occur while the insured is occupying a specifically listed vehicle, and because Ms. Harness was not in that automobile, the statute allowed Cincinnati to exclude her from UM coverage. The limitation in the Cincinnati policy appears to be designed to avoid duplicate coverage, which would have existed if it provided coverage for Ms. Harness, who also had her own coverage. As such, it is a permissible limitation under the statute. The Cincinnati policy simply does not provide uninsured motorist coverage for Ms. Harness's injuries. In my opinion, statutory interpretation by an appellate court must be reasonable and directed to fulfill the intention of the legislature. Finding that it was appropriate to allow an insured and its insurer to limit its uninsured motorist coverage to named vehicles and limit Ms. Harness's coverage so that she purchased for her own vehicle and not allow her to double the available coverage by recovering from her own employer's insurance, which the insured refused to purchase. Reasonable interpretation made it appropriate to affirm the trial court's decision. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog, and if you do, you'll receive notice of every blog posting, usually 5 or 6 a week, and you'll also gain access to the more than 5,050 blog postings. You can also subscribe to these videos on rumble.com and youtube.com. They're all free. And if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. Please tell your friends and colleagues about this blog so that they too can subscribe. And if you're interested in further detail about insurance, insurance claims, insurance law, and insurance fraud, please consider for a very small fee subscribing to my Substack publication. Thank you for your attention.